Hello everyone, it's your friend Rick. It is May 6th, 2017. If you need to contact me, it's rick0327@me.com. Okay, I wanted to talk about contempt of a fucking fake court order. Excuse me for cursing. Just gets me annoyed that some people have to suffer and be jailed based on a fake administrative order. So I want to, if I was facing contempt or alleged contempt, that's what I would say. They can't hold you in contempt of a void judgment. All of these judgments are void because they're not based on, they're not based on evidence. They're all based on presumptions. Let's put it this way: they would never jail a man. Not in today's climate. They did back in the day. I mean, there's plenty of, poor men who were in prison for 20 years for something they did not do. Which is the reasons for, Supreme Court cases like Miranda versus Arizona, which is the you have the right to remain silent. The way I see it, that Miranda warning is still applies even in these bullshit hearings, because if you're facing possible imprisonment or being jailed, there's two separate, being jailed and imprisonment, two different things. You're jailed when you're awaiting trial, or jailed for a fine, which the Justice Department says they're not supposed to do, which is was the purpose of the Department of Justice memo. So you have a right to know, you have rights, and they're supposed to tell you your rights. But unfortunately, what we're dealing with, you go in there blind. And for some of us, like myself, who knew our rights and questioned them, they would just ignore me. Okay? But getting back to my point before, in today's climate, they would put a man in prison for 20 to life based on presumptions, because that can ruin a prosecutor's life, a judge's life. I love it when, unfortunately it's under bad circumstances, but I love when a judge gets in trouble for releasing somebody that they should have kept in jail. And listen, there's some bad people out there that belong in jail and belong in prison. Okay? There's some people out there that have no regard for human life. So they belong in prison. Okay? They're predators out there. But and a judge gets jammed up because he wasn't doing his job, or she wasn't doing her job, and some poor family is made to suffer because their family member was murdered or killed by a drunk driver, somebody that should have been in prison or in jail. So, but they have no problem doing that when it comes to child support, because child support is viewed upon in the public as, we deserve it. You're a deadbeat. You're a deadbeat. You deserve to you deserve to go to jail. They steal your image. One guy was telling me this morning in an email. They access the database in the DMV. So they steal your likeness, which is your image, and they put it on a milk carton or something, or Facebook, that you're a deadbeat. I would sue these people for that. And I got news for you. That's a case that could be won. Because that's a case where I would sue them, for basically for slander, because they're ruining your good name by placing you on a wanted list that you didn't do anything wrong. So you could say, all right, well, just prove to me that I owe a debt, which is one of the hardest things that we've been facing. You know, in this, since I've been helping people. You know, when I first started doing this, you know, with the affidavits, you know, we were sending out these validations of debt affidavits, and they would always come back. They would either be unanswered, or some shitbag attorney that works for child support would say, well, the Court of Appeals and this court and this lower court says child support is not a consumer debt, or it's not a debt under the Fair Debt Collection Practices Act, which is hysterical. But it is a debt under the consumer protection laws. So it's still a consumer debt. But they won't substantiate the debt, because when they can't substantiate it, it must be discharged. Because they can't. It's a religion. Child support is nothing but a religion. They believe you got to pay child support, and when you say, okay, well, show me proof, it's like, you know, show me proof there's a God. Well, look at the beauty and, you know, who, they think this is all an accident? Okay, I can understand that argument. But child support's much more simpler. You're telling me I owe all this money, and tell me, you know, why? Where's the law that says I have to make this payment? Where is this proof that I'm an obligor? Okay, obligor means I'm obligated, meaning a contract. Where is this contract? Where is this undertaking? Where is it? Where? Why can't you show me? Why won't you show me? Why do you got to use all these little, you know, trickster case laws and claim you don't have to because this court says you don't have to? Why don't you just be, you know, a responsible person and show me? They can't. That's why. And they know they can't. And they're all in on it too. I mean, these lawyers, they're not stupid. You know, they work in law for a reason. They know all the tricks of the trade, as they call. They don't answer questions directly. There's this one attorney that works in child support in New York State. Her name is Nikita Valsek, and I've sent paperwork to her, a bunch of other people that subscribe to me, and we all get back the same letter from her. She doesn't do anything. She just sends it out. And the last paragraph is telling you to still pay your child support. She won't answer. She doesn't answer any questions. So she'll respond with this bullshit, you know, pre-made letter, but she doesn't answer questions when she's supposed to. Another subscriber sent me a letter yesterday. You know, something sent back where an interrogatory was sent to the director of the child support. And this is what they always do. Happened with me, everybody. The person that you sent it to never, ever responds. So meaning a director. The director, the commissioner, whoever, never, ever responds. It's always a lawyer. Same thing with these writ of quo warrantos to a judge. It's never that judge, it's another judge that responds. Because there's deniability there. Because the response is, they know that the response is supposed to be the response you're asking for in the interrogatory. An interrogatory is a device to gather evidence. It's not just asking questions. It's a device, and it's used all the time in civil law. Whenever there's, you know, instead of, you know, spending money on a deposition, a cheaper version is doing the interrogatories. You know, I did a video. They advocate interrogatories, but when it's time for them to respond to our interrogatories, they never do, because it's nothing but trickery. It's a complete fraud. So I would keep going after these people with these interrogatories. You know, I have as part of my package, because I'm always making new affidavits, and guys, don't hit me up. If anybody's asked me for new paperwork in the last month, you got it. Whenever I mention an update, I get a million emails because everybody thinks it's like getting the new Michael Jordan sneakers or something. Everybody wants to have it. Okay, when I have like a significant update, I'll let you know. Okay, it's like I'm afraid to use that word update. Whenever I say update, hey Rick, I heard you on an update, and I'll get 100 emails, and I got to email 1,000 documents out because everybody thinks that they're missing an update. You got it. I made this over a month ago, and it's about dealing with a child support agency and dealing with an attorney that doesn't want to respond, or when they do respond to an interrogatory, it's under the veil of fraud, or you know, refusing to answer a question, claiming they don't have to. And I'm going to do a video on I got to do it on my computer. The next step for us, we're far gone. You know, we've been doing this for a little while, and I have one guy in upstate New York right now. He's this close to getting out, because he's taking it to that next step that I'm about to talk about right now, and that is getting a judicial intervention, meaning that you and this is also and this also proves that you're not really in court when you're in child support, because you have to do this. It's called a request for a judicial intervention. Is proof positive that we're not in a court, we're in an administrative court. Okay, so you have to get a judicial intervention. So you got to go to the court that's above, you know, whatever court, your superior court, whatever it is. It's usually an appellate court or Supreme Court, and you're going to file a writ of mandamus to compel, meaning you got to compel them to follow the law and answer the interrogatories. Writ of prohibition, prohibiting the child support hearings to conducting these proceedings, which is basically a controversy of $20 or more, without a trial by jury. Okay? They don't conduct trials in these bullshit debtor courts. Really, that's all they are. It's a debt court. Okay, I know in some states they have the child support in the same building as traffic. If you're housed in a building for child support where they have traffic court, it's not a real court. It's bullshit. Traffic court is not a real court. It's bullshit court. That's why when I was a cop, I caught on to that scam right away. And you know, I wasn't a big ticket writer. I didn't like hurting people. You know, when I first became a cop, I couldn't wait to write tickets to these asshole cab drivers in New York, because they drive like assholes. But one guy said to me, he goes, "Hey Rick, these guys could be at home collecting welfare." I you know what? You're right. I left them alone. So, you know, if they were driving like an idiot and I saw it, I'd yell at them or whatever, but I didn't want to hurt them in their pockets. I didn't like hurting regular people. I only went after shitbags. Anyway, the writ of prohibition is the court, the Supreme Court or the appellate court, ordering the inferior court, which is what the child support court is. It's an inferior court. It's called the Nisi Prius Court, which means before, whatever it is. It basically is everything that they do to you, they're allowed to do until you object. Okay, so that's the reason why when they issue these bullshit support orders, they do it, and then you have to object. Like in New York, we got 30 days to object, and it goes to the judge, and the judge usually finds some bullshit reason to dismiss your objection. Except I found the real way to object, and it's not to the court. Okay? In New York State, it's called the Article 78. And I'm going to do a good video on this, and it's in every state. So all you got to do in your state, just keyword writ of mandamus, mandamus. That's the same writs that I was talking about with the writ of quo warranto. It's a common law writ, but because they don't want common law courts, the Bar Association, they usually have it under another like civil practice law in your state. A court rule or whatever whatever it's called, where you live. And in New York State, it's Civil Practice Law Rule, CPLR 78. And lawyers never do this. Lawyers will do this if you're was discharged from your job, like a city job, or they suspend your suspend your driver's license, suspend your gun license. That's there's lawyers that specialize in that. You're wrongfully terminated from your job. It's usually the Supreme Court is judicially viewing an administrative decision. Well, that there proves that family court or child support court, because I don't feel like going through all the courts, Court of Common Pleas, Superior Court, Circuit Court, all of these different courts throughout the country, for the purpose of stealing your money under the guise of child support, which is, we know, child support, it's not really child support. It's recoupment of welfare under We Hunt versus Ledbetter. And there's another one, Blessing versus whatever. It's another case from Arizona, where it says that the sole purpose of getting child support payments is just to recoup the welfare expenditures, which is further proof that the children must be under or must be receiving public assistance. Well, I get plenty of emails from guys whose children were never on public assistance. It's just that it's such a money-making scam now. It's such a money-making scam that they got to grab everybody. And what they do is they want to grab guys like myself, who has an income. Because, my income, my pension and stuff, they gladly comply with these bullshit income withholding orders. And they fought me on it. I still got to fight these people on this. Okay? Because they gladly went along with that shit. So anyway, let me get back real fast on the contempt of court. You can't be in contempt of a void court order. It's that simple. Just recognize that. And if you are and you go to court, just say it that way. How can I be in prison for an administrative order? Okay? And if you are facing a contempt of court of being jailed, they are supposed to provide you with counsel, which wasn't always good because the lawyers work for them. I believe I had a guy out in California. His wife has been, I've been working with her for a few months now. He was supposed to have been jailed yesterday, and the commissioner said, well, I don't know who's giving you legal advice, but all of those laws don't apply here, like a dick. But meanwhile, I'm like, oh, really? The Supreme Court doesn't count in there? The Supreme Court decisions don't count? 45 CFR 303-101, which is the whole basis of what they're doing. That's how they get away with having these bullshit hearings without a jury and without a judge, because it's an expedited process. So, but anyway, well, come back here in August or else. You better pay or else. So, thankfully, Javier is not in jail right now, thank God. And I also know I helped another guy out in Colorado a few months ago. So, if you let these people know that you know what's up, they're less likely to put you in jail. Okay? So it's good to state on the record loudly and clearly, How can I be in contempt of a void order? And here's the case. It's called Exparte Davis. It's a 1976 case in Texas Supreme Court where a man was jailed for a contempt of a void order. And when he got out, they fought it, and it was found that the court that issued the order didn't have jurisdiction. Void order. There was no evidence. Void order. They violated his due process. Void order. These are all the things that I always fight for to say it's a void order. Okay? In my package, and it's been there for a while now, is an affidavit to set aside a void judgment. You could submit that as part of your paperwork because it's a void judgment. What they do is they play dumb and they'll go, well, the time limit's passed because they don't want to. In their mind, the support order is valid, so they're not gonna go over that. The statute of limitations, whatever. They play dumb. Oh no, you gotta appeal it. No, I'm not appealing. I don't have to appeal a void judgment. There is no defense for a void judgment. A void judgment doesn't exist. A void judgment is a fucking unicorn. Okay? It doesn't exist. It's a pink elephant. It doesn't exist. Okay? Alright, so listen, I'm going to finish up this video and say goodbye. And I'll be doing a video in a day or two about the writ of mandamus, writ of prohibition, writ of certiorari. And that's the next step to go when these... unfortunately, you got to pay money for this. That's the thing. But if you've gotten this far, you got to keep going. And like I said, my friend upstate New York, he's this close right now. Well, I saw the letter yesterday that basically they were stating that they see no reason why the judgment shouldn't be set aside. So that's good. It's very good. Okay. All right. So listen, guys, enjoy the rest of your day.